Good morning. I'm going to give everybody a minute to take their seats. Welcome to the Department of Justice. We are delighted to be hosting the second annual meeting of the National Right to Counsel Consortium here in the Great Hall. And we are proud to have provided support to the consortium as its members engage policymakers, criminal justice stakeholders, and the community about the vital importance of the Sixth Amendment right to counsel. I'm Lisa Foster. I'm the director of the Office for Access to Justice here at DOJ, and I'm going to serve as your master of ceremonies for what I am confident will be a thought-provoking day of action. This meeting could not come at a more critical time. We are witnessing in America today what can only be described as a crisis of confidence in our criminal justice system. Although most of the protest that has occurred throughout the country has been focused on law enforcement, if you scratch the surface just a little, you'll discover that many Americans are profoundly skeptical that the justice system is fair and impartial, that it works for low-income people, and particularly people of color, the same way that it works for wealthier Americans. And in many of our states, where the vast majority of people are charged and prosecuted for criminal offenses, that skepticism is justified, particularly with respect to indigent defense. This administration, through the leadership of both Attorney General Holder and Attorney General Lynch, has transformed the role of the Department of Justice in ensuring that the right to counsel is respected in the states. As the Supreme Court of Pennsylvania just observed in its landmark decision in Curran versus Luzerne County, a case where the Department of Justice, I'm proud to say, filed an amicus brief that was embraced by the court, the Pennsylvania Supreme Court said, quote, "The right to counsel is the lifeblood of our system of criminal justice." And the court went on, quoting the United States Supreme Court, to say that the Sixth Amendment right to counsel is, quote, "necessary to ensure fundamental human rights of life and liberty, and serves as one of the essential barriers against arbitrary or unjust deprivation of human rights." The Department of Justice could not agree more. And as you will hear throughout the day, the department has invested significant and substantial resources in improving indigent defense in the states. We have litigated, written briefs in support of the right to counsel, convened stakeholders, and worked with many of you to ensure that the right to counsel is meaningfully and effectively enforced. Indeed, I think it's fair to say that not since Robert Kennedy was Attorney General and led the successful fight for federal bail reform has the Department of Justice been as actively engaged in working to ensure, as Attorney General Lynch said, there is no price tag on justice. No one in the Department of Justice has been more central to the struggle to ensure justice for all than Deputy Attorney General Sally Yates. Deputy Attorney General Yates has served in the Justice Department for 27 years, first as an assistant U.S. attorney in the Northern District of Georgia, and then from 2010 until she was confirmed as Deputy Attorney General in 2015 as the U.S. Attorney there. You might not think, given her long career as a prosecutor, that she would be an ardent advocate of criminal justice reform, but you would be wrong. Deputy Attorney General Yates' tenure has been marked by significant efforts on behalf of defendants in our justice system, including her oversight of the Clemency Initiative and the grant so far in 2016 of 583 clemency petitions, and the DAG would be the first to remind us that the year is not yet over. Deputy Attorney General Yates has implemented meaningful reforms in the Bureau of Prisons, including the phase-out of private prisons and an insistent focus on reentry, education, and rehabilitation. She has embraced and enhanced the Smart on Crime programs begun under Attorney General Holder, and in what I consider a signature initiative, she has mandated implicit bias training for every Justice Department law enforcement agent and prosecutor. She is, as you are about to hear, equally committed to the right to counsel and using the power and resources of the Department of Justice to ensure that the right to counsel is upheld. Deputy Attorney General Yates.
Well, good morning, everyone. And to our guest here today, welcome to the Department of Justice. Lisa, thank you for your incredibly kind introduction, but more importantly, thank you for your fantastic leadership of the Office of Access to Justice. I also want to recognize everybody who is here today from ATJ for your absolutely tireless efforts here. Now, as I would expect just about everybody here knows, this office was created by then Attorney General Holder back in 2010 to ensure that we were doing everything we could here at the Department of Justice to increase access to justice in both the civil and criminal arenas, regardless of race or wealth or status. And the work that this office does is truly inspiring and is really central to the mission of the Department of Justice. Now, we've got a diverse crowd here today, made up of prosecutors and public defenders, law enforcement officers and community stakeholders, legal advocates and community activists. And this diversity is really a reflection of the fact that we all have a role to play in improving our system of justice and in ensuring that it lives up to our founding ideals. That's especially true for public defenders. As Lisa mentioned, as a federal prosecutor in Atlanta for over 20 years, I've had a lot of experience with public defenders. I have seen firsthand the relentless dedication to the cause of justice that public defenders exhibit each and every day, oftentimes in the face of difficult, if not impossible, circumstances. Public defenders are often understaffed and under-resourced, and that's not how our system is supposed to work. And I so admire what all of you who are public defenders here do every day to ensure that an individual's access to justice is not determined by how much money he or she has. Now, as Lisa mentioned, as you all know, we are at a crucial moment right now in our history where there's a significant consensus that has been built around the need to reform aspects of our criminal justice system. For the first time in a very long time, we have folks from both political parties on both ends of the spectrum who are finding common ground. In the last couple of years, I have spent time with people from all backgrounds, with correctional officers and inmates, with law enforcement officers and public defense advocates, from community leaders and community activists. And despite the differing roles that each of them has, and sometimes the differing perspectives that they have, the common theme has been clear from this, and that is that the status quo needs to change. Now, we're trying to do our part at the Justice Department. We have directed our prosecutors to stop charging mandatory minimums for certain low-level, nonviolent drug offenders. As Lisa mentioned, we have embarked on an historic clemency initiative, allowing the president to commute the sentences of more individuals than the last 11 presidents combined. And I'm sorry, Lisa, but I have to correct you on one thing. It's actually 744 individuals right now, but who's counting? With many more to come. And we have significantly bolstered our reentry efforts here, trying to ensure that once individuals have paid their debt to society, that they have the tools that they need to be able to be successful when they re-enter their communities. Now, all of this stuff is really important, but as we are strengthening our criminal justice system, I think we also have to remember that a core component of our system is that everyone, regardless of race or class or status, has access to competent counsel. Now, more than half a century ago, the Supreme Court affirmed what they called the obvious truth, that every defendant charged with a serious crime has a right to an attorney, even if he or she cannot afford one. In Gideon, the court recognized that adequate legal representation for the most vulnerable among us is really the bedrock of our entire criminal justice system. And while our nation has made progress in removing barriers to quality representation, the unfortunate reality is that 5 decades later, the promise of Gideon remains unfulfilled for far too many individuals in our nation. In every corner of our country, there are public defender systems painfully understaffed and under-resourced. Some offices have had to close their doors to new clients, and others are forced to represent a seemingly never-ending line of clients without the attorneys that they need to be able to provide adequate representation. The Bureau of Justice Statistics found that between 1999 and 2007, the number of public defenders increased by only 4%, but yet the caseload increased by over 20%. Now, when managing such huge caseloads, it can be difficult, if not impossible, for counsel to carry out their legal and ethical duties to their clients. At the department, we are embracing our responsibility to ensure that our country lives up to the promise of equal justice under the law. For example, in 2012, ATJ, under Lisa's leadership, launched the Legal Aid Interagency Roundtable, which brings together 22 different agencies from across the entire government to work to integrate civil legal aid into a wide array of federal programs. Now, what this means is that this roundtable has unlocked millions of dollars in assistance that can be used to connect Americans and legal aid providers to really vital services that are necessary, vital services in the area of health care and housing, education and employment, and other core needs for every American. In 2015, ATJ supported efforts to prevent the criminalization of homelessness. And earlier this year, the department issued guidance to state and local courts regarding their legal obligations with respect to the assessment and enforcement of court fines and fees, doing this to ensure that individuals are not jailed for being poor. The department has also filed 4 statements of interest or amicus briefs in courts throughout the country, arguing a constructive denial of the right to counsel in jurisdictions where public defender services were so under-resourced and understaffed that they essentially resulted in indigent defendants having counsel in name only. At the same time, earlier this year, we announced that the department was awarding $3.3 million to cities and states and defense advocacy organizations to support their indigent defense work. These awards will expand the number of cities who have an opportunity to participate in BJA's Smart Defense programs. These are programs where cities can use research and data to be able to ensure that their criminal justice programs are as effective as possible. And it also provides investment and risk assessment tools to be used in the pretrial release decision-making process and in reentry planning. Now, while all of these steps are important, and we hope that they're meaningful, our work is far from finished. And one area I'd like to talk a little bit about today is access to counsel at bail hearings. While Gideon and subsequent cases make clear that the Sixth Amendment guarantees court-appointed counsel to every indigent defendant who faces incarceration, there's still a question of when, precisely how early in the criminal proceedings, the Constitution requires that counsel be appointed. This is especially important when we're talking about a defendant's initial appearance. An initial appearance where a judge is likely to decide whether to detain the defendant or to release him on bail. Now, in the federal system, the rule on bail hearings is clear. Under the Bail Reform Act, defendants have a right to an attorney, and if they can't afford one, they have a right to have an attorney appointed for them. And that makes sense. The Constitution not only entitles defendants to a presumption of innocence, but also protects them from excessive bail. Yet many indigent and low-income defendants are unfamiliar with the full extent of those constitutional guarantees. Now, without a doubt, there are some defendants who are either likely to flee or who are so dangerous that they should be detained. But others should not. And given the serious consequences that can flow from a pretrial detention decision, from losing a job and housing, to missing school and defaulting on debts, it's crucial that defendants have counsel advocating for their rights. 8 years ago, in Montgomery versus Gillespie County, the Supreme Court held that the Sixth Amendment right to counsel attaches at a defendant's initial appearance. An initial appearance before a magistrate judge that is an important moment when the defendant learns about the charges against him and his liberty is subject to restriction. But the court has not gone the extra step and stated that a magistrate must appoint counsel for an indigent defendant at that point in criminal proceedings. A number of states, nonetheless, have taken that step and now ensure the availability of court-appointed counsel when a judge is setting bail. Other states, though, have not. And it's not uncommon for indigent defendants in some jurisdictions to be held in jail for weeks or even months before they're assigned an attorney who can advocate on their behalf. That's wrong, and that is inconsistent with our basic notions of fairness. In 1964, Attorney General Bobby Kennedy testified before Congress on legislation to overhaul the Federal Bail Reform Act, and he expressed his concern that bail had, in his words, become a vehicle for systemic injustice. And he diagnosed the problem pretty bluntly, stating that far too many men and women remained in jail simply because they cannot afford to pay for their freedom. Now, certainly much has changed since then, both at the federal level and across the states. But our Constitution prizes the right to counsel in criminal proceedings. And regardless of whether the Supreme Court determines that the Sixth Amendment requires it, it is clear to me that our nation's core values demand that all jurisdictions recognize the need for court-appointed counsel at a bail hearing. Not only is the defendant's liberty at stake, but so too is the fairness of our criminal justice system. Now, we may be in the closing days of this administration, but the fight for fairness will continue well into the future. We hope that others will continue the effort to secure access to counsel, including at bail hearings. And moving forward, we're going to keep voicing our ongoing support both for federal and state defender programs, including appropriate funding and resources. In Justice Black's historic Gideon opinion, he observed that the right of one charged with a crime to counsel may not be deemed fundamental and essential in some countries, but it is in ours. Thank you for what you all do every day to make our shared obligation to fulfill that promise a reality. Thank you.
Thank you. Let's have another round of applause for Deputy Attorney General Yates. And now it is my distinct pleasure to introduce Denise O'Donnell, who has served as the Director of the Department's Bureau of Justice Assistance since 2011. BJA, as most of you know, is responsible for the development and implementation of data-driven, research-based criminal justice policy and currently funds over 4,000 grants in excess of $2 billion toward that end. Prior to joining BJA, Director O'Donnell served as the Deputy Secretary for Public Safety in New York State and as Commissioner of the New York State Division of Criminal Justice Services. She served as the chair of the New York State Commission on Forensic Science and the New York State Commission on Sentencing Reform. She's the former United States Attorney for the Western District of New York and a former Assistant United States Attorney. It is through BJA that the Right to Counsel Consortium, as well as numerous other programs supporting indigent defense, are funded. Director O'Donnell.
Good morning, everyone, and thank you for being here and joining us in the great hall here at the Department of Justice. I am so excited today because we have participants, as the Deputy Attorney General has said, from all across the country, ranging from national leaders in the public defense community to judges, to legislators, to policymakers, and even a few prosecutors in the mix. The diversity of the group reinforces the fact that the right to counsel is not just a policy that we should strive to implement, but a constitutional right that we are entrusted to uphold. The Bureau of Justice Assistance is a unique component at DOJ in that our mission is to support the work of our state and local stakeholders. Our overarching mission at BJA is to reduce crime, recidivism, and unnecessary confinement, and to promote a safe and a fair criminal justice system. Since becoming director at BJA, I have asked our BJA team to focus on a couple of key areas. First, ensuring fairness in the system, including building trust, enhancing procedural justice, and ensuring that core services are in place to ensure that constitutional rights are a reality. Second, using data and research to better understand and target the issues. And third, in addition to BJA's mission, as you have just heard, of reducing unnecessary confinement, both pre-trial and post-trial adjudication. Support for public defense is a critical component in achieving these priorities and a strong and vital focus of DOJ during this administration. I'm very proud of the hard work of BJA's staff and all of our partners in this room, so many of whom have helped to advance these important goals. The purpose of the Right to Counsel Consortium is to focus on how we can continue to make the promise of Gideon v. Wainwright a reality for indigent persons at every stage of the criminal justice system nationwide. How can we raise a national awareness around the importance of meaningful public defense services? And how can we achieve a fair and equitable justice system through setting up effective defense delivery systems throughout the country? And I can't believe it's a year since you first started this important work. BJA plays an important role in helping to advance this work. Through the development of a strong public defense program like BJA's Smart Defense program, programs that are not afraid to innovate, that are willing to have their work measured and evaluated, we are growing the body of knowledge about what effective defense is and how it can improve the criminal justice system. With training and technical assistance from the National Legal Aid and Defender Association, Smart Defense is one of 10 programs in the larger BJA suite of SMART programs that use evidence-based practices and research partners to develop effective models that will improve and advance our public defense system. The current Smart Defense sites are Alameda County, the state of Kentucky, New York City, Texas, Wisconsin, and new this year, Costa County. One of the most important components of Smart Defense is that it incorporates a practitioner research partnership at its core. The research component is very important, and BJA has invested a lot to get the field thinking how best to use research in developing effective programs. In the public defense field, as in many other components of the criminal justice system, this is a relatively new concept. Few criminal justice researchers have worked with defender offices, and few defender offices have experience working with researchers. So we all have much to learn. But there is a lot of excitement and opportunities for doing so, and the potential for where this can lead us is beyond measure. For example, in Alameda County, we are helping to implement a comprehensive pre-arraignment services program. What does this mean for the county, which in 2014 had close to 25,000 new criminal filings? It meant that most of the people appearing before a judge and prosecutor did not have representation, even though decisions had lasting consequences for them. And they were being made in cases that affected their lives. The data bore this out. In review of just the Oakland Misdemeanor Arraignment Court, over 3.5 months, 1,138 people were arraigned without a public defender, and therefore remained in custody. All of these defendants were then released a day or two after a public defender entered the case, suggesting that close to 75 people every month lost a day or two of their lives, interrupting their family and work lives unnecessarily because they lacked defense at that critical stage. Because of smart defense, Alameda is now turning the tide. We are also working with Kentucky and New York City to develop strategies to enhance the quality of assigned counsel tracking, to assess the quality of private assigned counsel in a variety of ways, including perceptions of the judiciary, the numbers and kinds of cases assigned attorneys handle, and the disposition of the cases. Public defenders and other court leaders need good information about where defense services are needed and deployed, assessing the quality of work and supporting informed decisions by policymakers. Texas and Wisconsin are leading this effort. The Texas Indigent Defense Commission is developing a smart defense portal that will create a dashboard that gives state-level policymakers a snapshot of the overall well-being of indigent defense, including places where the state excels and places where greater focus is needed. Wisconsin state court leaders are developing the Reporting, Analysis, and Mining Project that will integrate the state public defender's individual case data with case data of the Wisconsin court system to more accurately measure the quality of indigent defense. Another BJA program, Gideon's Call, is focused on elevating the quality of public defense through improved training and workload management. Through in-person and free web-based training programs, the National Association of Criminal Defense Lawyers, the training and technical assistance partner for Gideon's Call, has provided training to jurisdictions across the country. Just this past March, they delivered a training in Oxford, Mississippi on taking the fear out of forensics to give defenders in Mississippi, Tennessee, and Alabama a better grasp of the science behind forensic testimony in the courtroom. NACDL also provided a webinar on defending interrogation cases, presenting information on interrogation techniques that present a danger of producing false confessions, and discuss strategies for litigating such cases. In addition to these types of trainings, grant funding is available under Gideon's Call for scholarships for defenders to get training needed to be more effective in their roles. By the end of September, the close of the fiscal year in 2016, more than 115 public defense practitioners have received scholarships totaling more than $40,000. Gideon's Call is also working to address the very real issue that the Deputy Attorney General raised about large caseloads public defenders are managing. For the past 2 years, NACDL, working with the ABA, have been conducting workload studies in the state of Rhode Island and Knoxville, Tennessee. Report on their findings will be available later this year and will hopefully help to shape the direction of caseload management in jurisdictions across the country. BJA's investments in public defense are not just about training or collecting data or even furthering research and producing results. They are about fairness. There is a growing body of criminal justice research in the area of procedural justice that has confirmed something that most public defenders have experienced for a long time, namely that when a person who comes in contact with the justice system believes he or she is treated with dignity and respect, understands the criminal justice process or has it explained to them, has a chance to be heard or a voice, and believes that the decision-making process is neutral and unbiased, he or she is more likely to accept the decision in their case and is more likely to comply with and follow the law moving forward. At a time when mistrust in the criminal justice system is at a peak, effective representation by counsel improves perceptions of procedural justice. That is why BJA is committed to this work and to improving public defense delivery systems overall. And while we are working on training our public defenders, educating the public on the importance of the constitutional right to counsel, and ensuring fairness throughout our criminal justice system, we also have to address the issues around unnecessary confinement and the importance of counsel at every step in the adjudication process. The Pretrial Release Advocacy Project with NACDL is a key partner in this effort by focusing on states that are already reforming their pretrial release procedures and using risk assessment tools to help judges determine which clients should be released from custody while awaiting trial. We are taking steps toward integrating evidence-based practices in a meaningful way. The development of research and data and using evidence-based practices is critically important to making the case to those who have not yet solidified their position on the importance of the right to counsel, as well as in building support for the resources needed to advance your work. In closing, I want to express a note of thanks to Kim Ball, who, as most of you know, has left BJA to accept an exciting position at American University, for the keen advocate she has been on behalf of both public defense and pretrial justice during her time as a senior policy advisor at BJA. I also want to thank Associate Deputy Director Betsy Griffith, who's over here, who is supervising this work at BJA and standing in for Kim until her replacement is on board. Thank you also to the talented staff at AU who supports the work of the Right to Counsel Consortium and today's meeting. Last but not least, we owe a debt of gratitude to Lisa Foster, who has been a great director of the Access to Justice Office at DJA and partner to us at BJA, and to our Attorney General Loretta Lynch and Deputy Attorney General Sally Yates, who have enthusiastically followed the tradition of Eric Holder in making public defense a top priority at DOJ. It is our hope that our work together will help the American people understand the importance of the right to counsel, help jurisdictions better manage their public defender programs, and increase the effectiveness and quality of public defense in the fair administration of justice for all. Thank you for the dedicated work that you all do. We have a great agenda in the day ahead, and I look forward to seeing the results of the Right to Counsel Consortium in the months and the years to come. Thank you.
So now from the sublime to the mundane, we've inspired you and motivated you for the day ahead. Let me turn to a few housekeeping matters. You came in this morning through a special Attorney General's entrance, but when you leave, you will need to go through our regular visitors center. And if you need to leave during the day and want to come back, which you may do, you will need to go out of and then back through our regular visitors center entrance. That is on the Constitution side of the building. You'll walk down that hallway and turn left. It's on Constitution between 9th and 10th. You should please keep those lovely green badges visible at all times that you're with us in the building. Bathrooms are at the end of the hall, outside, on either side. We'd ask you please, when you're in the hallways, to be quiet. There are lots of people working all around us. If you want to take a break and meet with someone quietly or need a quiet space, the best place to do that is in the courtyard right behind you. It's a lovely day outside. You just walk back and then down the stairs and out into the courtyard. There is no Wi-Fi in the Great Hall of Justice. I apologize. It's just a sad reality of this building. This morning, until lunch, the meeting is open to press. So you can feel free to tweet using hashtag #RightToCounsel with the number 2 in it. You can also find us on Twitter at @RightToCounsel, again, the number 2 in between right and counsel, and on Facebook at #RightToCounsel National Campaign. Biographies of most of the panel participants, or all of the panel participants and speakers are in your materials. When I introduce people, I'm going to be very short. If you want to find out more about who they are and the great work that they've done, please refer to those bios. If you need anything throughout the day, there are DOJ staff and interns here. I'm going to ask them all to stand up so that you can see them. Anybody who's an Access to Justice, BJA staff person, they are here to help. Just find one of them and ask a question. As you will see on the agenda, our day today is divided into 3 parts. We're going to look retrospectively, briefly, at where we've been. We'll examine in greater detail where we are now, and we'll look prospectively at what needs to be done and discuss ideas for how we can achieve our goal of ensuring meaningful representation for all in our justice system. To address the past and give you a brief overview of the contributions consortium members have made to improving indigent defense, we're going to turn to Preeti Menon. Preeti is the Senior Policy Associate at the Justice Programs Office at American University, and more importantly, the Project Director for this Right to Counsel Consortium. Preeti?
Good morning. I have to put this down. Thank you so much for the Department of Justice for supporting this Right to Counsel initiative, and then also for hosting the 2nd annual meeting. This great hall is one of my favorite spots, so thank you so much. And for recognizing the importance of Right to Counsel. Like Lisa said, my name is Preeti Menon. I am a Senior Policy Associate at Justice Programs Office. It is a center at the American University's School of Public Affairs, and I'm also Project Director for the Right to Counsel initiative. I just want to start with a little story. When I first got involved in criminal justice policy, my focus was mostly on the overall court system, and also at looking at how different components of the justice interact. In 2008, as a BJA policy advisor, I was tasked with putting together a focus group on public defense. It was a one-day event, and it was an event where I learned quite a bit about public defense and the dire need for reform. That was 8 years ago. For me, the focus group was just the beginning, and as I continued to work on my adjudication portfolio, I thought about the importance of counsel and the improvements needed in public defense on a regular basis. However, I wasn't able to dedicate the time to it until I truly became immersed in this Right to Counsel national campaign. And having seen the issues that you'll hear during the day later today on a regular basis made me realize that the change of this magnitude of what we're trying to achieve here, it takes time and constant reminder. So during this time, I began to see the impact, during the time of my involvement in the campaign, I began to see the impact that public defense has at every stage of the criminal justice system. From beginning, the pretrial stages, to mass incarceration, and then also even during reentry. And as Lisa Foster, the Director of Access to Justice, and Deputy Attorney General Sally Yates, and Director O'Donnell, they just spoke to this as well. And I just want to point out that we get so busy in our day-to-day lives that often it makes it difficult to focus on something that we learn in a one-day meeting. And so I just want to stress the importance that it takes to actively reminding ourselves of the importance of public defense on our daily lives. So we can't just take this one-day meeting and go back. We have to constantly stay involved. I'm going to start, can you, okay, great, thank you. As you know, Right to Counsel National Campaign kicked off officially last year in an inaugural meeting. Our mission, I just want to point out, is to inform and engage policymakers, criminal justice stakeholders, and community on the importance of meaningfully carrying out the Sixth Amendment right to counsel. We've built a broad-based coalition of stakeholders, all of you who are here today, who've given this topic and the support and the importance that it needs. And we've also come up with a collective vision, which is a fair and equitable criminal justice system requires representation by skilled defense counsel with adequate resources at every stage of the criminal process. Okay, next slide. Okay, over the past year, our consortium members have kept their promises that they made during the inaugural meeting, and they've reached out to their constituencies at their national conferences, at their regional events, through webinars, and by distributing material online. Some of you have been actively following us on Facebook and Twitter, so thank you, and reposting and retweeting, and it's been a very exciting year. And like I mentioned before, this is just the beginning. We have much more work to do. And I cannot possibly go through everything our consortium members have accomplished over the past year just during this short session, but I'd like to go through some highlights from the year. Go ahead, next one. In September, we presented at the American Judges Association's annual conference. A session titled Judges' Role in Ensuring Constitutional Right to Counsel discussed the role of judiciary plays in meaningfully carrying out the effectively carrying out the constitutional right to counsel. It was one of the best sessions I've ever had an opportunity to moderate. Two of the panelists from the session are here today, Norman Reamer, the Executive Director of National Association of Criminal Defense Lawyers, and Judge Betty Moore from Shelby County, Tennessee. After the session, the past and current presidents from American Judges Association asked us to continue the conversation, and they already have us on the agenda for their mid-year and their next annual meeting. Go ahead. At American University, we've had an opportunity to coordinate efforts with all of you, and there's one particular effort on highlighting public defense and reentry that we hosted just recently. This was part of DOJ's National Reentry Week. In April, American University, in collaboration with public defense national organizations, hosted a remote town hall on the role of public defense in reentry. And this webinar, and pretty much everything that I'm going to list today, it's on our website at the Right to Counsel website, and also we've been putting it on Facebook. We've also, at the Justice Programs Office, have hosted a webinar for public defense in drug courts. So just to give you an idea, we're trying to cover and show how public defense should be inserted and also thought about in all these different stages and different aspects. Okay. The National Association of Counties have been an amazing champion for right to counsel for us. They have continued to highlight the importance of public defense in county officials through webinars and sessions throughout the year. And we do have Megan Gilmore here from NACO. Megan, say hello. There she is. NACO also presented at the National Association of PRETRIAL Services Agencies annual conference for us, and Colette Tavet, who's the Director of Public Defense Training and Reform at National Association of Criminal Defense Lawyers. She's been presenting with NACO at their annual conference and then also at the National Association of Pretrial Services. With National Association of Court Management, NACM, the engagement and interest from court managers and administrators in Right to Counsel has truly, truly been wonderful. During the sessions at past July's annual conference, we had people coming up to us afterwards asking on advice on how can they get involved. So this picture over here is Raj Jayadev, he's a community advocate from Albert Koberis Justice Project, and he's presented on participatory defense at several venues, including as part of NACDL's training in discussing family and community involvement in courts. And so his involvement, and he's also used social media to help do the outreach. National Association of Criminal Defense Lawyers. I cannot say enough that they've done. They've been a key Right to Counsel National Consortium planning partners. NACDL has been a true collaborator in providing continuous support. And I could do a whole session on the work that they've done, but I just wanted to highlight one of the reports they put out in April from South Carolina, titled Summary in Justice, a look at constitutional deficiencies in South Carolina's summary courts. Is just an example of some of their work, and there's material in the back that we have from NACDL, so please feel free to pick that up, and it's also on their website. With the National Association of Public Defenders, they released its 2015 annual report, All Day, Every Day Public Defense, featuring the day in, day out advocacy that public defenders provide in jails, courts, and communities across the country. They held a webinar in February in collaboration with John Rapping of Gideon's Promise, entitled The Missing Chapter in the Criminal Justice Reform Story. John's passion and commitment to improving public defense is truly commendable, and I wish he was here today because he wasn't able to make it, but he's been a true champion as well. And they also hosted a webinar in March, which provided overview of the Right to Counsel National Campaign. And with the DOJ's National Reentry Week, they collaborated with American University to do a host of blogs, so it's been wonderful to have them as our partners as well. National Criminal Justice Association. We're working with state administrating agencies, and at the National Criminal Justice Association's regional pre-trial meeting, we were able to present and talk about the importance of counsel at pre-trial. We also hosted a breakfast with experts at NCJA's annual conference and discussed the right to counsel with the SAAs there. And we're hoping, well, we are planning to host a roundtable with the SAAs and to talk about systematically and strategically how they should include public defense and where they can do it, and brainstorm with them on ideas. National Legal Aid and Defender Association. Also a key Right to Counsel Consortium planning partner. NLADA has provided much of the behind-the-scenes support. Again, as a national public defense organization, I will not be able to list everything they've done. However, they've been working with public defense public defense providers and non-public defense partners, and have been actively involved in improving state and local public defense delivery system. And Joanne Wallace, and a good friend, she's here today from NLADA, and is the executive director there, and has been one of my go-to person for everything. Next. With Pretrial Justice Institute, Right to Counsel National Campaign teamed up with them to do a joint campaign on hashtag Right to Counsel and on hashtag 3dayscount. And also just looking at how we can use the power of social media to advance and get the word out. Charisse Burdine is here as well. And Charisse, are you in the room? There she is. And thank you so much for your support and partnership. Okay. Sixth Amendment Center. David Carroll and his staff at Sixth Amendment Center, they're also part of our planning partners for the Right to Counsel Consortium. They have been an amazing resource when it comes to looking at public defense reform at the state and local level. We could set aside an entire day worth of sessions for them as well. However, today I'm just going to highlight their work in Utah, where their report on Utah reform established a state indigent defense commission. And if you haven't had an opportunity to see that report, it is online, and we may have copies in the back as well. And thank you, David, for all your work, and David is there as well. David, there he is, next to Charisse. Okay. With the Constitution Project, they've been looking at federal legislations, and they've been providing our consortium members with updates. And in providing us with updates, they have provided a caveat that while the prospects for adoption of most of these bills may be quite slim, but we're pleased to see the increased interest in issues concerning indigent defense in an effort to ensure that concerns with the Sixth Amendment part of the discourse related to criminal justice reform efforts. So it's been wonderful to have them be on top of it. So all of our partners, they've kind of been tackling different avenues for us. There's been this pronged approach to this campaign. Justice for All Reauthorization Act, it also reinstates a previous requirement of Burn JAG program that state develop and update annually a strategic plan detailing how grants received under the program will be used to improve the administration of criminal justice systems, including defenders, in such a plan. With Equal Justice Under Law Act, it confers on federal courts the jurisdictions to provide declaratory and injunctive relief against systematic violations of the Sixth Amendment. And with the Independent and Effective Federal Defenders Act, it creates a commission within the executive branch to provide adequate representation to indigent defendants in federal criminal cases. And status of the Sixth Amendment Act requires all states in receipt of federal criminal justice grant funding to annually submit a report to DOJ, cataloging the timing of appointments, type of counsel assigned, and case outcomes for all criminal offenses, and juvenile delinquency proceedings in the previous year. With the National Center for the Right to Counsel Act, establishes a national center to provide financial and substantive support to improve the delivery of the right to counsel to indigent defendants. All of this information is also on our website, and there's details about it, and we will continue to update and provide you input. As you can see, our consortium members' activities over the past year demonstrate the importance of public defense across the continuum of the justice system. It has been a busy year, and there's still ways to go. So please continue to stay engaged and help us reach other criminal justice stakeholders and state and local policymakers by spreading the word. And before I leave, you have this commitment sign in your folders. In using social media to highlight the importance of counsel, we love for you to write why you are committed to safeguarding the constitutional right to counsel. And so if you take the moment to think about it, write them. We will take a picture of you and spread the word using social media. So thank you so much for all that you've done over the past year, and I'm truly excited to see where we're going to be this year, and continue the good work. Thank you.
I'm going to ask our panelists to come up and have a seat. Our next session is Securing a Meaningful Right to Counsel, Perspectives on State and Local Reforms. This session will speak to what's happening today in indigent defense at the state and local level. The panel will discuss how best to identify and overcome systemic deficiencies in indigent defense through legislation, litigation, and public education approaches. The conversation will include different perspectives from various justice system stakeholders, including judges, state legislators, and public defense providers. We've divided the panel into two parts, and we will have a break in between them. The panelists are going to be looking at Utah's consensus approach to reform and the advancement of evaluation standards, Idaho's recent legislative reforms, and why conservatives are at the forefront of advancing the right to counsel, federal litigation in Washington state and state litigation in the state of New York, and the role of the Justice Department in both. And finally, excessive public defender caseloads in Missouri and a successful media campaign. The panel will be co-moderated by David Carroll, the Executive Director of the Sixth Amendment Center, and Colette Tevet, the Director of Public Defense Training and Reform at the National Association of Criminal Defense Lawyers. David, Colette.
Thank you, Lisa. I'll take a cue and keep the introduction short, knowing that you have them in your packet. But I've had the great pleasure and privilege for about 20 years of traveling all across this country, sitting in courtrooms, conducting observations, and also, probably more importantly, sitting down with criminal justice stakeholders and policymakers and talking about their right to counsel systems. And during that time, I've met a number of great people who became leaders and also who I consider friends. Joining me today is Judge Derek Pullen from the 4th District in Utah. I met Judge Pullen through the Utah Judicial Council Study Committee on Indigent Defense Services, and we'll be talking about those efforts today and his crucial role in that. I will also be asking questions of Representative Christy Perry from Idaho. Christy has been a real leader on indigent defense. I've first met her probably 4 years ago in the initial effort to have a legislative task force look at this issue. She spearheaded the creation of the Idaho Public Defender Commission. She led a continuing legislative task force that then subsequently empowered that commission with the ability to enforce standards. And subsequently, she became the vice chair of that commission. So she not only started it, she's seeing it through. And I'll turn it over to Colette to introduce the other two panelists.
Is Corey coming? Well, we're still waiting for Corey Stoughton, but I'd like to introduce Eileen Farley, who's going to be talking to us today about the work that she's doing as the independent monitor in the Wilbur litigation in Washington State. And Eileen took this position 3 years ago. Prior to that, she was the head of the Northwest Defenders, one of the premier public defender agencies in Washington State and in King County. We also have Corey Stoughton. Hi, Corey. And Corey's going to be speaking to us today in this first panel about the statement of interests that have been filed by the Department of Justice, ATJ CRT, in the Wilbur case, and then the second panel about in the Harrell Herring case. And many of you know Corey. She's the senior counsel to the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. Before that, she was one of the senior counsel for the New York Civil Liberties Union and has done remarkable work to forward the right to counsel in her efforts.
So when we were asked to talk about the current state of indigent defense, we thought it would be good to talk about the various stages different states are in. Starting with those states that were the least organized and working up towards the ones that were the most organized. For most of my career, Utah was, there was very little known on the national level. There wasn't a lot of participation in national groups by the indigent defense providers there. We would occasionally get information on Salt Lake City, but as I've learned, Utah is not just Salt Lake City. And so I was very happy when one day we were approached by the Utah Judicial Council Study Committee on Indigent Defense to begin a conversation about how to begin looking at their issues. And with that, I want to turn it over to Judge Pullen because he was there from the beginning from an appellate study. And I'd like to ask you sort of what was the precipitating factor to want to look at trial-level indigent defense services?
This began with the Judicial Council Committee on Appellate representation. And as the Judicial Council looked at that, it became clear that the right to counsel needed to be examined in the trial court. And ultimately, the Appellate Study Committee was converted to a trial court study committee. The Judicial Council is the managing body of the judiciary in Utah. And I think it's important to understand essentially Utah's delivery system of public defense services. In Utah, the state has delegated all responsibility for indigent defense to local governments, specifically 29 counties and 236 municipalities. So that's a lot of indigent defense systems. There is no state funding for that, and ultimately no oversight about whether those counties are providing that the constitutional level of service or even capable of doing that. And so ultimately the study committee got together and we tried to understand what was happening in counties throughout the state, and it was difficult to determine that because there was no data being collected. It was an absolutely overwhelming responsibility for members of a committee who have day jobs and are trying to do that work. And at that point, we approached the Department of Justice, and we are ultimately one of those 4,000 grants. We are so grateful that we were able to leverage federal money to promote real change in Utah. I can't begin to express the profound gratitude Utah has for those funds. We were able to partner with the Sixth Amendment Center to help us, and I will just say the Sixth Amendment Center was a remarkable gift to Utah. They are careful in their research. They conducted countless interviews. They collected the data that we couldn't, and ultimately produced a report. They were sensitive to local concerns and ultimately maintained their independence at the same time, and produced a report that gave us meaningful change.
Thank you for those kind words. One of the things we're very interested in when we went to Utah, generally when we look at how to evaluate services, ever since 2002, in whatever capacity I was doing these reports, we looked to a document called the ABA 10 Principles. It's 10 simple tenets that indigent defense systems must meet to have efficient and effective services. I think a little times we became a little complacent about those, and people started thinking of those as the core, that they had to be done because the ABA said they had to be done. And so when I first landed in Utah, I was interested because they said, we don't want to be measured against the ABA. And I said, okay, what do you want to be measured against? And at that point, that I think is the first time I met Judge Pullen. And I'd like you to talk about the efforts to create Utah-specific standards and the effort you specifically went under to do that.
I have to give you background, I guess, to see our difficulties. At the time I came onto the committee, they had been a committee, I think, for about 18 months and had really struggled with this issue. We had the ACLU on the outside that had threatened to sue Utah in either individual case-specific instances or class action efforts regarding the system. And so there was the reluctance on some committee members to look too carefully because we would be creating Exhibit A for the ACLU and their lawsuit. And ultimately, I and others said, look, the facts are what they are. And we're either going to discover what's happening on the ground ourselves now, or we're going to discover it in the context of civil litigation. And we ought not be afraid of those facts. The other concern was, do the ABA principles, are they aspirational, or do they really reflect what the Constitution requires? And there was a debate within the committee about that. Ultimately, there is always a concern about where is the money going to come from to to fund public defense, and what does the Constitution require? That was a sticking point for a long time, and ultimately we said, we're a bunch of fairly smart people in this room. We ought to be able to define what the Constitution requires. And ultimately, I and others were able to draft 7 principles of what the Constitution standard is. And I think these are in your materials in an article that we've provided. But ultimately, the 7 standards are this. Representation should be independent, such that the public defender isn't fearing retaliation in terms of compensation, getting the contract next year, or the limitation of defense resources. Representation should be without conflict of interest, either in case-specific instances or systemically. Representation should be without state interference, and it should be provided at all critical stages. Finally, representation should ensure what we call the fair fight. There should be meaningful adversarial testing of the state's evidence by qualified counsel who has access to defense resources and with a reasonable caseload. Finally, we talked about fair compensation, not necessarily parity with the prosecution, but what's fair, and there should be proper incentives. What we found in Utah is many counties were actually contracting with a public defender at a flat rate, and then if you hired a defense investigator, it came out of that flat rate, and so did your overhead, and so did your appellate costs, and so there's a disincentive to provide zealous representation. And finally, important to the whole system is the idea of oversight, that we would have someone that was looking at case-specific public defense, but also the system as a whole and assessing its health over time. Once we agreed to those 7 principles, I think David had something that he could run with, and we were able to compare Utah's actual performance on the ground to those 7 principles and get a diagnosis of what the constitutional health or disease was within the system.
What I like about the standards that they came up with is one, the judge spoke about the fair fight in particular, and that's really mirroring the language in United States v. Chronic. And with the DOJ's statement of interest and amicus briefs, there seems to be a coalition around sort of the focus of reform and evaluations and litigation are around actual and constructive denial of counsel, and we'll get into that with some of the later panelists. But I do want to thank you because our latest work is in Mississippi, where we're just about done with site work. And Mississippi, too, did not want to be evaluated against ABA standards. And so we brought Judge Pullen's standards down and explained what they did, and they said, yeah, that sounds about right. So we seem to be coalescing around certain themes. And we're not going to have enough time to go into detail on all of these states. We could have done 45 minutes on each. But in the last few moments on this section of the panel, I do want you to talk about the consensus approach that was taken towards reform on the backside of the report, because I thought it was a great model for other states to emulate in moving forward with reform.
We began with, as I said, this study committee, and it consisted of prosecutors and public defenders. There were representatives of the League of Cities and Towns. There were judges and legislators, and we all coalesced around the idea that we each had a constitutional obligation to ensure that the Constitution of Utah and of the United States was upheld and defended. And that consensus approach, I think, is ultimately important because we are all participants in a system that was failing. I think there were important decision points along the way that I'd just like to emphasize. The first is, as I've indicated, that the threat of litigation against the state should not make us reticent to pursue meaningful reform. Second, the identifying of a constitutional standard by which we can measure health. But lastly, I think we had an obligation as a study committee to courageously accept bad news. The report of the Sixth Amendment Center demonstrated that in Utah, there was both actual denial of the right to counsel as well as constructive denial. And that was hard for us to hear because we're all participants in that system. And the truth is that we each bear a personal responsibility for that systemic failure. I think that's a critical moment. We can either at that point try to minimize or back away from the bad news, or we can take that as a call to action to do something. I just like to conclude with something that Justice O'Connor said. She said this is in her book, The Majesty of the Law. Some might find it a bit frightening to consider that the responsibility for protecting our Constitution rests not just on judges, but on a host of others as well. I find it quite comforting. By spreading the responsibility to uphold the Constitution among so many, the framers enlisted a legion of defenders for their new charter. And that's how I feel about this consensus approach. Every public officer in Utah takes an oath to uphold, obey, and defend the Constitution. And that's what can bring us together to make meaningful reform. But we can't be afraid of the bad news. I remember the day that David was there. It's a critical moment to say, are we going to put this out there and do something, or are we going to run away from it?
Thank you. And before we turn to Washington State, for those who aren't familiar, Utah did pass comprehensive reform this past spring under the leadership of Senator Todd Weiler. They created a statewide indigent defense commission with authority to set and to promulgate and enforce standards. The first ever state funding of indigent defense. And so leaving Pennsylvania as the only state that has never contributed any money towards indigent defense. Although we do have to put South Dakota back on the list, unfortunately, this year, so there's still two that aren't funding. But it was a major step forward, and what you'll see from the other panelists is this is a big haul. This isn't something you flick on a light switch and everything's fixed. Utah was sailing in the wrong direction for years. This legislation has righted the ship, but there's a lot of work to go to get to where they all want to be. But I'm confident in the people on the ground there that they will do it. And with that, I'll turn the panel over to Colette to talk about Washington State.
Great. Thank you, David. I echo what has been said on this panel already, that in my new role at NACDL, I'm able to go to courtrooms all over the United States, and in every single day, in every single state, you see actual denial of counsel where no lawyers are appointed to represent poor people, and constructive denial of counsel where overworked, underfunded public defenders without the resources are being appointed to represent poor people. We have seen some really strong, dramatic changes in some systemic litigation, and we're going to start with talking about what happened in Washington State in the Wilbur decision. And if many of you were here last year for the first annual Right to Counsel meeting, Judge Robert Lasnik, who authored the Wilbur decision, spoke to the audience about his role in this litigation. And what it was is that the plaintiffs sued originally in Superior Court. The case was removed per the defendants to federal court. And they were suing over the constitutional deficiencies of the representation in 2 counties in Washington State. 2 lawyers were given the flat fee public defender contract, and they could also have a private practice. And what you learned during the course of the trial in federal court was that these 2 lawyers would dispose of over 1,000 cases a year with nary an investigation, speaking with experts, doing any pretrial litigation, any type of trial work. They were a meet, greet, and plead mentality. After the court had heard the testimony, the Department of Justice, and there was a recognition of constructive denial of counsel, is that how can these lawyers be actually representing people that they are meeting with for moments in a courtroom before they plead their clients guilty? And as one of the defendants said in that case, when asked why they were pleading all of their clients guilty, he in essence said, and I want to quote this directly, trials are not necessary because we all knew what we were doing. And before the judge issued a decision in Wilbur, the Department of Justice entered a statement of interest, with Corey's going to tell you a little bit about what these robust statements of interest that the Department of Justice has been filing in the last several years, and what difference did that make. Ultimately, Judge Lasnik ruled in favor of the plaintiffs and found that there was a constructive denial of counsel for those poor people in those counties. And Judge Lasnik concluded in his opinion, quote, "The notes of freedom and liberty that emerged from Gideon's trumpet a half-century ago cannot survive if that trumpet is muted and dented by harsh fiscal measures that reduce the promise to a hollow shell of a hallowed right." So I want to start with asking Corey Stoughton about these statements of interest that are being filed in some of these strategic litigation, and including in Wilbur.
Thanks. Well, thanks so much, Colette, and thanks for inviting me to this panel. I really appreciate the opportunity to talk about the Department of Justice's work on right to counsel issues. You heard the commitment that this department has in the Deputy Attorney General's remarks this morning, and you'll hear more of that from my boss later on today, Vinita Gupta. So I'll dispense with that and kind of try to get into a little more of the brass tacks of what we do and situate those statements of interest within the department's many tools that we have for addressing right to counsel issues. You know, we have the Civil Rights Division itself has some enforcement authority, not on the issue of juvenile representation. We don't have enforcement authority when it comes to adult representation in criminal cases. But and you heard the Deputy Attorney General talking a bit today about the great work done at the Office of Justice Programs and the Bureau of Justice Assistance on providing some financial and policy support on this issue. But another source of authority that the Department of Justice has to weigh in on this issue is through our authority to file statements of interest in cases that are being litigated that raise issues of interest to the United States. And again, as Deputy Attorney General Yates made clear, the United States has a very strong interest in the vindication of the Sixth Amendment right to counsel in the United States. And so our goals really in filing statements of interest in these cases is to solidify the foundations and really shore up and build out the promise of Gideon versus Wainwright. Because we've all been to conferences like this before, and we've heard again and again, and many of you live daily the reality that Gideon has been an empty promise for too long. And with the work of advocates who have been doing this litigation, with the work of people who are doing it every day, doing the work every day in public defenders' offices, with the policy advocacy and leadership from state governments of some of the folks up here on the panel, and with the statements of interest, I think we're finally getting to that place where there's a much broader recognition that the Constitution doesn't just require that there be a lawyer appointed, but that the Constitution requires that systems be in place sufficient to support constitutional representation. Is that better? And so I've never been accused of not being loud enough before, so it's unusual for me. So, so our goal there is really to, again, to shore that up and build out the meaning of Gideon in those cases, and to strengthen and establish the legal consensus around what the Sixth Amendment means, and in particular what it means for addressing the systemic deficiencies that get in the way of lawyers being able to test the prosecution's case and ensure that they're giving meaningful and effective assistance to their clients. So it began in Wilbur. There was the first statement of interest that the department, the Civil Rights Division working with Access to Justice initiative here at the department, put in, and that was, I wasn't there at the time, but I can tell you that the positive feedback that the department got on that was extremely encouraging. And following on from that, as you know, the department's filed statements of interest in New York in the Hurl Herring case, in Pennsylvania, and in Idaho. And I want to encourage everyone to keep us informed. The department is looking for ways to ensure that whether it has to be done state by state or it can be done in a federal court, that those legal principles become the consensus view, that we want to get to a world in which there's not a pocket of the United States where there's any controversy over the fact that the Sixth Amendment can and must be enforced through systemic challenges, and that governments fulfilling their constitutional obligations have an obligation to ensure that the systems by which they deliver public defense have to be sufficiently funded, sufficiently independent. All of those principles that the judge spoke about today are there to ensure that the Sixth Amendment has meaning. And so I want to thank everyone for the cooperation that you provide the Department of Justice. We can't do this work on our own. We can only do it on the backs of, in a certain sense, and in cooperation with advocates and reformers around the country, and we look forward to continuing to look for opportunities for that partnership to continue.
Thank you so much, Corey. And, before I turn it over to Eileen Farley, I really beseech you to all read the statement of interest. They're fabulous. And the Wilbur decision issued by Judge Lasnik and the Department of Justice's statement of interest in the Wilbur case really kind of outline. It's really a beautiful template for some of these litigations that have been taking place in other jurisdictions. NACDL, if you go onto our website, and you go onto statements of interest, we link to all of the statements of interest that have been filed by the Department of Justice. One of the things that the SOI in Wilbur and then ultimately in Judge Lasnik's decision was that they granted injunctive relief. And one of the things that they were ordering, Judge Lasnik ordered, was an independent monitor to go into these counties, a small little project for someone to take over. And I'm really delighted that Eileen Farley was given that Herculean task. And so the first question I want to ask you, Eileen, is what was it like when you first got there? And what are some of the steps that you've taken to try to ensure that poor people have good representation?
Thanks. Well, I just wanted to also follow up. I brought some unreadable slides, which if anybody wants to email me later, I will send you. But like Utah, Washington has 39 counties and about 300 cities with very different approaches to how public defense services are provided, and they vary in quality. Unlike Utah, I came into these, it was cities, after things blew up, and it's probably, there'll be some DSM 3, 4, 5 diagnosis for jurisdictions that have been on the losing end of a federal lawsuit that gets national press. So when I arrived, the city said, the city administrator, just tell us how to make it right. And it's an interesting question because if you pointed out all the ways that a jurisdiction fails to provide adequate public defense services, what do you tell these jurisdictions in terms of this is what you need to see in your public defense system? Judge Lasnik identified certain factors in the representation that he wanted to see with the focus of developing an attorney-client relationship. Is there prompt contact? Is there investigation? Is there an immigration consult? People going to trial? If you read his decision, he identifies those. Washington State also has, by court rule, very minimal standards for anyone who accepts appointment of a public defense case, whether it's a conflict counsel or an organized office. And they're pretty minimal. You have to have a place to meet confidentially with a client. You have to meet certain qualifications, which for a misdemeanor attorney are pretty minimal. You have to, and this was the most controversial, adhere to caseload standards. And as Colette mentioned, prior to these standards, people, and I would say they don't represent, they would handle 1,000 cases. And that just meant, to me, processing paper. There are now definite limits on how many felonies are a full-time caseload, 150, 400 for misdemeanors, which is pretty high, but it's a lot less than 1,000. And so, unfortunately, oh yes, and then you have to have a place to receive mail. So these are not really onerous standards. Those in combinations with the points that Judge Lasnik identified formed the basis of the assessment that I was going to do. The information that was gathered, and I don't know, can you go, all right, so what has happened, just to go granular, is that and maybe if you go all the way to the end, the insurance pool for the municipalities is, keep going, there we go. They became very interested in how can we measure whether or not our member cities have adequate public defense. And this, they hired this lawyer, a guy named Scott Snyder, with Ogden Murphy Wallace. I have nothing to do with the firm, there's no commission. And he put together a slideshow, which again, I can provide you. I merely wanted to bring this and one slide, the next one, that, keep going. This was his message. You've got to assess it now. This is what they told their members. So you can find allies in different places for public defense, and consistent with what the city said, they want to know, just tell us how to do it. And if you go back, what happened with, go back more, I'll just keep, okay, good. So now the cities report monthly on various things. This is scrubbed of client identifiers. I cleaned it up a little bit, but it talks about these courts only have 3 days of trials, jury trials a month. So what happened in the trial? Was there a trial? What was the outcome? Is it happening? And if you go back another one, they also report their hours. Again, scrubbed of client identifiers, but in a month, in this case, you know, were you seeing investigation? If you go back one more, are you going to the jail? This is a jail that's so crowded you can call in because they can't, the visiting rooms and attorney rooms are all used for special needs people, but they also go to jail visits. So we identified certain factors, and again, I'm happy if people email me, that a public defense system should have, that people should be doing. And it needs to be reported to the cities in a way that's comprehensible. You also need, which means you need to have capacity in the city for someone to read these, understand them, and then to have authority if there's a problem. Since my position is supposed to end in March, the cities just this month, both cities unanimously passed or created a position for an auditor to continue after my term is up. The auditor will have a contract for 4 years that overlaps the mayor's. It can be terminable only for cause, and the person they're now going to be recruiting, and it's not going to be that easy to find people, but to build into these cities, into their DNA, that you have to have a public defense system that's robust, you have to have somebody who looks at it, and you have to have measurable terms. I mean, none of these necessarily mean you have a great relationship with a client. There will still be mistakes, there will still be things missed, but it's going to tell you if you have a public defense system that is vigorous and active. The other thing the auditor is going to do is to comment before the city councils on the proposed budget. This is going to be a huge cultural shift. As the judge noted, there are a lot of ways public defense is delivered across the country or across our state, and there are a lot of places that still use for-profit firms. So you need to have a pretty active discussion with people about what your expectations are, and you need to have very clear terms about what is needed. But I also think that you have a great opportunity for allies, not just the insurers, but my group, I'm chair of the State Council on Public Defense, organized a mental health summit a couple of weeks ago, focused on folks who cycle through the system repeatedly. We had the healthcare authority there. We had officers both in the jail and on the street who do the crisis intervention training. We may not agree on the methods, but there are a lot of people who want a justice system that provides fairness and community safety. And if you have a way to engage with those folks, you can build a good justice system. And if you don't have that, the best advertisement for a bad justice system is bad public defense, because it just confirms for everybody who comes through the system and their family and their friends and their neighbors that this is a system that cares nothing about them, it is irrelevant to their lives, or at the worst that it needs to be actively resisted. So I think you can build a lot of support around that idea that we all want fairness and community safety. There are measurable ways to move toward that that allow us to have communities that agree and work with the laws that we want to see enforced in order to accomplish that.
Thank you.
Our final panelist is Representative Christy Perry. Idaho was a step above.
Sorry.
Idaho was a step above Utah and Washington State in that even though trial level services looked very much similar to those in the other two states, since the late 90s, Idaho has state-funded and state-administered all appellate defender services. It was through the appellate defender that a lot of issues were identified on the trial level. And Representative Perry was at the forefront of an interim legislative committee looking at those issues. What I was particularly interested in talking about is nowhere have I seen such a genuine and thoughtful discussion about the balance between state and county responsibility for indigent defense, and in particularly the expansion of criminal justice by the number of cases. And Representative Perry, I was hoping you could start with that discussion that the interim committee had about what is the role between state and counties.
Thank you, David, and thank you also for inviting us. Idaho is actually very excited to be able to speak about some of the reforms that we did here. We know that they are going to be extremely meaningful, and we're really looking forward to that. We have already noticed how the reforms that we have put into place will actually roll over into other avenues and arenas as well. Specifically, I spoke to a couple of people regarding foster care reform, too. So I would like everyone to know that when I speak to you, I really do probably speak through that creation of policy lens, because that's really where my particular place was. And it was really interesting. As we sit here and talk, I realized how much Idaho actually mirrored Utah. And as we began really researching what were some of the improvements that could be made in Idaho, we also delegated our responsibilities for public defense through our county system. And we have 44 counties. We did not use the cities, but it did run through the county system. We did not have state funding. We did not have oversight mechanisms. And when we began to have our conversations, most of them were questions surrounding data, and come to find out we didn't have that either. Even though we did have statutes in place that required our public defenders to submit their data to the administrative court judges, we had no definition of what a public defender was. We also did not have any enforcement to back up that statute. So we really felt like we were starting from ground zero. And ground zero also meant, what is that relationship then between the state and counties? And at this point, our county spoke up and said, well, wait a minute, we don't think there should be a relationship. As a matter of fact, we think the state actually should have it. And we had a very robust conversation and maybe battle between the state and the counties on that, where some of the counties felt that the state in delegating, really abdicated their responsibility, where other counties felt like, no, it really is ours. And ultimately what happened is you look to the Sixth Amendment itself, and the verbiage of the Sixth Amendment in part says that people are allowed the right to an impartial jury of the state and district where the crime was committed. And when we look at that, and the insertion of the words "and district" in our minds meant that it becomes very local, and that's where public defense really should take place. And so as we had that conversation, we went through those counties. We said, no, we really do believe that you really should participate here. And there is that balance. We couldn't find a single county that could say, no, we really don't believe in the Sixth Amendment. Absolutely everybody understood and knew that people have a constitutional right to that public defense. However, the question really then became, how do you protect that right? And how do you do it equally and in a balanced manner across the state, especially when you deal with states where resources vary widely. So in Idaho, not only do we have some urban centers, we have what you would probably consider rural, but Idaho also has what are considered frontier counties, where you may have possibly 700 people in a county that's probably larger than some of your eastern states. And so resources and these types of things become very, very difficult. And how do we balance when we have an urban center and we have all the resources available there? How do we actually go ahead and do that completely across the state? And we found that to be extremely important for us. Our ultimate goal was to ensure that we had parity of resources across our state and that our citizens, regardless of whether they were arrested in a rural or an urban or a frontier county, that their rights were protected equally. And that balance required cooperation. And that cooperation certainly came over a number of years and through a number of conversations. But ultimately, we are now in the process of that. And I think that they've realized that this really is a good mechanism. So we stayed with our county implementation model, but the state did jump in to assist financially where we had not before.
One of the most interesting aspects of the Idaho reform to me is the enforcement mechanism about what the state can do if a county is found to be willfully not meeting standards. Can you talk about that?
Yes, thank you for that question. That was probably our biggest battle of our entire policy, and that really was the enforcement mechanism. Because we were left with dealing still with this inner battle between the state and the counties themselves could not decide on whether they simply wanted to abdicate to the state or whether they believed they should be partners. We worked very closely with the Idaho Association of Counties. They tried desperately to get consensus. They could not. Ultimately, our counties were split almost 50-50 on really what they believed their role to be. So when it came down to actually creating an enforcement mechanism, many of the legislators who participated in our committee were basically ending up being proxies for their local county commissioners, because that actually is their job, right? And so they would have to come in and stand up for their county commissioners, although their role as a state representative as well really put them in quite a conflict. So ultimately, because Idaho is a very conservative state, we also do tend to look at ultimate control or local control, which actually ends up being local implementation more than anything else. But we were able to come up with an oversight mechanism. And what we did were a couple different things. What became very important in a conservative state is that government is not too big, it is limited, and it is not heavy-handed. And so how do you balance being able to make sure that we can enforce without really hitting them over the head with a hammer? And so our enforcement mechanism is probably a little lengthier than maybe you may see in some other states, but for us, we felt that this was really going to work out, and we were able to get majority consensus on this. So our commission that we had previously created was given the authority to determine if there were any deficiencies in a county, and then when those deficiencies were noted, it was immediate that the county and the commission then were to sit down and discuss these issues and see if they could come up with some consensus. If consensus or agreement on that issue could not be be met, then a mediation process was to occur, with the cost of mediation to go between both the counties and the Public Defense Commission equally. If after mediation we were unable to remediate the noted deficiency, then our commission was going to, we would go into our Administrative Procedures Act. And that way the counties were able to have their due process of law and not feel as though the commission could just simply come in and order them to do something. So Idaho Administrative Procedures Act would then take its place. If we've gone through all of this and we simply could not still come up with a remediation and the administrative procedure determined that the deficiency was warranted, then the commission was empowered to be able to step in and go ahead and go into that county and remediate the deficiency. Now, when that happens, however, what would happen was our fear was that counties would go, great, you go right ahead and come on in and take over. And that was really what we wanted to try to avoid. So if we have to come in and take over and remediate a deficiency, then the counties then are responsible to pay for that. Well, they kind of have the same kind of attitude that a lot of us have, going, well, I'm just not going to pay the bill. And so at that point, we also wrote in that the state can intercept any sales tax receipts that the state sends to that county. We would intercept those at the state treasurer level and go ahead and take that funding from them. And that seems to be enough at this point, that was a good enough fear, really, without actually coming in and hitting them over the head and taking over initially. But it also allows both sides to have their time to remediate, to discuss, and then also go through due process. And if at that time we ultimately landed on, then we would go ahead and do that. But so far, this process seems to be working out.
Colette has a question.
I have one question. How do you, what's the oversight for that? So if you have someone in a frontier, county that's not doing what they're supposed to be doing, how are you checking up on that? Yeah.
Thank you for that question. So what we did was our Public Defense Commission has now been authorized to be able to do that, and we are creating positions basically that we are calling liaisons. And our Public Defense Commission, I think it's really important to understand that from the very beginning, when we rolled everything out, and it is a long process, but we are not coming in as a government agency with a heavy hand. We are here to assist you at your ground level and to help you understand what resources you have, what you're doing well at, and then maybe what you're not. And so we are building in liaisons that will work for the Public Defense Commission. Exactly, we believe they're probably going to be over some regions, but they can be actually ground level people then that can kind of help and be that middleman between the commission. But ultimately it is that commission.
Thank you.
Great. And we're bumping up against our break, but I do want to put you on the spot a little bit, Representative Perry. When I talk across the country about the fact that conservatives are at the forefront of indigent defense reform, a lot of people are taken aback. I think there's a particularly Northeast bias that this is a progressive issue and a progressive issue only. So when I tell them that the legislative leader in Idaho is a conservative gun shop owner,
Yes.
people tend to look at me very strange. So I was hoping you could take a moment and just talk about how the right to counsel fits in with a conservative political philosophy.
Thank you. And you're right, people are rather shocked by that. But the Sixth Amendment, as all amendments actually really should be viewed from a conservative viewpoint, and they should be supported. Conservatives ultimately believe in limited government. They believe in individual responsibility, but they also believe in individual liberty. And individual liberty clearly lands right here in the Sixth Amendment, and therefore it really is up to us to defend that individual liberty. We also believe in that limited government. And in the courtroom, or when a person is actually charged, all of a sudden you have all the resources of the government against a lone individual, and oftentimes many of them are indigent. And so for those of us who really believe, we see that, even if as a conservative viewpoint, we see that as an unfairness and unjust in our opinion. And so therefore, even in Idaho, our discussion was never about should we be leading here, and is this really where conservatives belong? Absolutely, this was where conservatives belong. we thought it was really at that heart of that conversation. We saw a need for improvement. This was not a rich man, poor man fight. This is not a Republican or Democrat fight. This was really all about what was the right thing between government and citizens. And so we thought that we squarely landed there. And Idaho has actually been very proud of the improvements that we made.
Yes, I'm very optimistic for the work that's being done there. So we're up against our break. We had intended to give the audience a chance to ask questions of this panel, or the panel to give a final thoughts. Maybe we can take a minute or two and just see if there's questions from the audience before we take a break.
Oh, we did so.
In the back.
David, I'm curious. The examples that you highlighted were from Utah and Idaho. And I'm kind of going to address the 800-pound gorilla in the room. I served on, my name is Darrell Atkinson, I served on our Indigent Defense Commission in North Carolina. And one of the obstacles to properly funding public defense, in my estimation, has been racism and classism. The two examples that you brought up, Idaho and Utah, are culturally homogeneous states. And I'm curious if you think the reforms and the consensus that's been achieved in those states are transferable to states where the population is more diverse and where you have to combat some of those underlying biases.
I do. I think it is transferable. I am currently working with a state Supreme Court task force in Tennessee, and as I previously mentioned, we're doing a statewide study in Mississippi. What we find is that when you frame the Sixth Amendment as a tyranny of big government against individual liberties, it creates a big enough umbrella to encompass both the left and the right. So unfortunately, tyranny often goes after the people with the least amount of voice in the political process. And in our country, and particularly in regions of the South, those tend to be the communities of color. And so if you frame it, and this is obviously, we're not going to fix all the problems of racism and disproportionate minority contact in discussions such as this, but I do say when you're able to frame it from that perspective, it allows the people that are working on this on the behalf of people of color or Native Americans or whatever the minority group is, and bring along conservatives because they can look at it from this tyranny of liberty versus individual, tyranny of government versus individual liberty approach. So it's not easy lift, but I do think it is transferable.
The second big requirement was the completion of a social media operational use.
Great. Anyone have last minute comments, or we all go to break?
So the smooth would basically
Thank you very much.
Thank you.
Thank you, David.
Oh, really?
I thought it was